Hello and welcome. My name is Jeremy Glover, and it's my pleasure to welcome you to our latest Fenwick ELLIOTT webinar. This week, we're taking a practical look at prolongation costs, looking at some of the key points which those seeking to make and resist claims for prolongation costs under particularly the JCT and NEC forms should bear in mind. And joining us this week are Fenwick ELLIOTT partner Claire King, who's the author of our Insight publications, which always take a distinctly practical approach to topical issues, and that will include issues such as prolongation. And we're also joined by Four-Pump Court barrister Sanjay Patel, who's been described in the legal rankings as someone who is commercially minded and legally astute, with a strong reputation for his handling of complex construction and engineering disputes, just the type of dispute where prolongation and issues relating to prolongation will crop up. So before I hand over to them, just a reminder that you are all on mute, but please do send in any questions you may have for our speakers, and you'll be able to find the slides on our website later in the week. We'll be trying to put a link into the chat during the webinar. But Claire, the floor is yours.
Thank you very much, Jeremy. So just to outline what we're proposing to cover today, first of all, Sanjay is going to cover at a high level what are prolongation costs and what we mean by that. He's then going to have a look at the key case law relating to prolongation costs and their recovery. I'm then going to dip into the standard forms and what they provide for, focusing on the JCT and the NEC for today. And then last of all, we're going to take a bit of more of a deep dive into key types of prolongation costs, divided into increased preliminaries and on-site costs, on-site overheads, and also looking at increased off-site costs, although I know sometimes people exclude those sorts of costs from the definition of prolongation costs. So with that in mind, I will hand over to Sanjay to start on what are prolongation costs.
Thanks so much, Claire, and thank you, Fenwick ELLIOTT, for inviting me to speak this afternoon, and also to so many of you who've logged in. We're really bowled over by how many of you have joined us this afternoon. I'm going to start with something slightly esoteric. In 1748, Benjamin Franklin wrote his advice to a young tradesman, and he said that time is money. And that phrase has been immortalized ever since by Gordon Gekko types around the world. And in some ways, that's a good maxim in relation to our world of projects. And the reason for that is because delays always, or almost always, cost everyone money. The employer doesn't get the use of their building when they contracted to receive it. And that means that they will probably incur additional costs of one kind, or they'll lose out on profit on the projects that they intended to build. And the contractor will also have to maintain its costs on site. So its management presence, its site office, its insurance, and other things besides. So delays cost everyone money. So in that respect, time is money. But whose money? Is it the employer's money or the contractor's? And as we all know, the answer to that question depends on the cause of delay. Generally, construction contracts give financial remedies to both the employer and the contractor in relation to delay. The employer's remedy is almost always liquidated damages. If the contractor doesn't complete their works by the contracted completion date, as adjusted by extensions of time, then they will pay damages at an agreed rate. And the contractor's remedy is the subject of our talk today, prolongation costs, also known as loss and expense under the JCT forms. If an employer risk, such as late design or a failure to grant access, causes delay to the overall completion of the project, then the contractor can recover the costs that they would not have incurred but for the employer risk event. So what's the purpose of prolongation costs? What are they trying to achieve? And the more complex questions that we're going to come onto in this talk really the answers to those questions start with a solid understanding of what prolongation costs are trying to do, or what those terms are trying to do. And the purpose is to compensate the contractor for time-related costs that they would not have incurred but for employer risk delay events. And that chimes with the SCL delay and disruption protocol, which is on the slide there. And so breaking down the relevant concepts, as we've got in that last bullet there, what the contractor needs to show is two things. First, that it has actually incurred the cost that is the subject of the prolongation cost claim. And second, that the cost has been incurred because of the employer risk delay. And both of those things are more complex than they seem. And that's actually the reason why Claire and I are devoting the best part of an hour to this talk. Now, one of the awkward conversations that I tend to have at the beginning of a dispute goes along these lines. The contractor spends a large amount of time and effort proving an entitlement to an extension of time. They have their critical path analysis ready, and they show, let's say, an entitlement to a 150-day extension of time. Fantastic. Then the awkward part of the conversation comes when we talk about prolongation costs, because sometimes there can be an assumption that if you're entitled to a 150-day extension of time, that you will get 150 days of prolongation costs. And it's at that stage that people like Claire and myself have to gently explain, with love, care and attention, why it may not be that simple. And the reason it's not necessarily that simple is because the analysis required to prove an extension of time is subtly different to the analysis that's required to prove an entitlement to prolongation costs. And the reason for that is this: when we're dealing with an extension of time, we are adjusting the contractual completion date. The focus of the analysis is on whether the contractor has been given the full agreed contractual period to complete the work. If their progress has been prevented by something that is the employer's risk, and that's affected the overall completion of the project. So again, let's take our example of a 150-day extension of time. If the contractor's progress has been hampered such that overall progress has been delayed by 150 days, then they will be entitled to an extension of time of 150 days, because that's the period that the employer risk has affected overall completion of the works. Now, this analysis that I've just been talking about in relation to extensions of time doesn't really take into account when the contractor would have finished their work if the employer risk event had not occurred. That's just not relevant, because unless the contractor's own delays are on the critical path, you don't need to take them into account for the purposes of working out whether or not the contractor is entitled to an extension of time. But we all know that contractor delays may well have played a part in the works. So for instance, on one scenario, even though the employer may have caused delays of 150 days, as in our previous example, and that may have driven the overall completion, in one scenario, the contractor may have been right on their program, not caused any delay whatsoever to their scope of works. And so in that scenario, but for the employer risk event, the project would have completed 150 days earlier. But in the second scenario, the contractor may have caused non-critical delay of 149 days. In that scenario, but for the employer risk event, the project would have completed just 1 day earlier. Now, in relation to extension to time, it does not matter what the extent and scale of contractor non-critical delays actually was. It could be no time at all, or it could be 149 days. In either scenario, the contractor would be entitled to an extension of time of the full 150 days. But it does come into the analysis when we start talking about prolongation costs. You see, the point of prolongation costs is to compensate the contractor for costs that they would not have incurred but for the employer risk delay. The contractor will not be awarded costs that it would have incurred anyway. So what you're trying to do is work out the costs that the contractor would have incurred but for the employer delay. And in this kind of claim, it's essential to consider the extent of the contractor's non-critical delay. So returning to our 150-day extension of time, if the contractor is working to their programme and the only delay to the work as a whole is the 150-day delay to completion that the employer is responsible for, then the additional time-related costs for 150 days will be the costs that are recoverable by the contractor as prolongation costs. But if the contractor was actually in 149 days of non-critical delay at the same time as the 150 days of delay caused by the employer, then they'll only be entitled to 1 day of prolongation costs. Now, some people have described this distinction between the analysis relevant to an extension of time and the analysis relevant to prolongation costs as the difference between excusable delay and compensable delay. And just to explain what I mean by that, excusable delay is the delay for which the contractor is entitled to an extension of time and therefore is excused from liquidated damages, whereas compensable delay is the period for which the contractor is entitled to prolongation costs, and that is a key difference. Now, I don't know about you, but I tend to think that these things are best illustrated with pictures. And so we're going to have a picture now. These are the Petronas Towers in Malaysia. I've picked this picture not because I have any detailed knowledge about these towers whatsoever, or that I've worked on them, or that I know that there was a dispute about them. I'm simply picking these towers because it is a project with two ostensibly independent towers that could be built independently of each other, except for that small link bridge halfway up. Now, I want you to imagine on this project, this hypothetical project, because I don't know whether this happened or not, that there are two delays. On Tower 1, the employer cannot give the contractor access for a period of 5 months, from the 1st of January to the 1st of June. And as a result, no progress is possible on Tower 1 during that period. But at the same time, the contractor's groundworks subcontractor for Tower 2 becomes insolvent. So for that reason, again, there's no progress on Tower 2, but this delay in relation to Tower 2 only goes from the 1st of January to the 25th of May. So in this scenario, where there are overlapping delays, how would the prolongation cost claim work? How would the extension of time claim work? Well, there would be an EOT from the 1st of January to the 1st of June, that being the critical delay, the longest delay, and that would be 151 days. However, but for the employer delay, the overall project would only be finished around 7 days earlier, and that's because of the contractor's delays on Tower 2, so you'd only be entitled to prolongation costs for 7 days. So that's how it works in theory. Now, on this next slide, I'm going to do a cardinal sin of webinars, because what one should do on webinars like this, especially extremely well-attended ones such as this one, is not to give a view on open questions of law. However, I am going to do that here. There is not a lot of law on how the but-for analysis works in relation to prolongation cost claims, surprisingly, because these are very common claims. How do you set it up? How do you set up the analysis? Well, on one view, what you do is you retrospectively look at all your as-built information and you assess what the length of the delay is on the critical path, and that will be something that you need to look at for the purposes of your EOT claim anyway. And then you also look at the as-built information in relation to non-critical delays, and what you simply do is do a straight comparison between the two and work out, by reference to the as-built information, what when the contractor would have completed their works but for the employer delay event. And I would expect that if I were acting for an employer, that would be the sort of thing, the sort of analysis that I would want. However, we all know that it can be a little bit more complicated than that in relation to lots of different kinds of projects. If you know that there is a critical delay affecting one part of the works, then you don't typically resource non-critical works in quite the same way. You don't bust a gut to finish non-critical works much more quickly, simply to defend your right to prolongation costs. And it could be actually a positively silly way to resource your project. I'm thinking of a particular project on where I worked with Fenwick and in relation to an energy from waste plant. And the facts that I'm going to put forward were not, in fact, the facts of the case that I was engaged on. But often you have a waste treatment side of the plant, and then you have a power generation side of the plant. Now, if you know that the power generation side of the plant is causing critical delay to the project, you probably aren't going to commission the waste treatment side extremely quickly and then leave it idle, possibly with flammable fuel inside a bunker for months upon end, because that would just not be sensible. What you're likely to do is to pace what's going on the waste treatment side so that the two sides of the plant can be commissioned in parallel. Now, if you make that sensible decision about resourcing, should that prejudice your prolongation cost claim, simply because if you look in the as-built data, those two sides of the plant are ready at the same time, are ultimately ready at the same time? I would say that's not terribly sensible, and it doesn't really reflect how contractors or employers expect their works to be resourced. So I would suggest that a straight comparison of as-built information just isn't the right way necessarily to assess compensable delay. Now, for those of you that don't just think about this in ivory towers, but actually have to progress works, what I would suggest to you is that if you know, and if you are actually managing a project where you need to delay an activity, or you're going to push it back in some way, or you're going to withdraw some resource from it because of critical delay to a different part of the works, document it, raise it in meetings, say that's what you're doing, so that when you need Claire's services or my services, we can look back at a record saying this is what you did, this is why you did it, and this is why we think it was sensible. So as with almost every talk I give about construction law, it all comes down to records. So what's the takeaway? Well, the takeaway is that, to return to our Benjamin Franklin quote earlier, is time money? Well, unfortunately, in the particular context of contractor claims for prolongation costs, time doesn't always equal money. Prolongation costs will involve an additional analysis of the cause and extent of non-critical delays caused by the contractor. But as I've just said, have a think about what the real effect of critical delays has been on other work streams on site. Has there been some pacing? If so, perhaps there is scope for saying that the effect of the critical delay on other work streams has been larger than the as-built information would suggest. Just have a think about that when you are putting together your records on site. Different topic now. What information do you need to submit in order to make your claim for prolongation costs on site. Now, something that I see often, if I may say, on non-UK projects, is that there are clever wheezes for the less than independent engineer or architect in order to refuse to assess a prolongation cost claim because they say that insufficient information has been provided. And this is sometimes a slightly underhand way of just kicking out a contractor's claim. Now, I have to be absolutely frank with you. I have seen submissions by contractors, I'm sure Claire has too, which have been plainly insufficient. It's not enough, never enough, frankly, to simply submit an impacted programme unaccompanied by any other kind of record and say, I would now like hundreds of thousands of pounds in prolongation costs. That is not sufficient. But more commonly, I do see submissions that do contain detail, especially given that the claim, particularly under amended forms of FIDIC contracts, needs to be made within 14 days, sometimes very aggressively 7 days of the event taking place. And the contractors tried to do the best they could to submit detail with their claim, and the engineer repeatedly rejects those claims on the basis of insufficient information. Now, my perception of the case law is that the English courts really do not like this at all. And the high watermark is the Walter Lilly and Mackey case, sometimes known as Walter Lilly against DMW, which is cited at the bottom of this slide. And that was dealing with the JCT form of contract, but we can take wider principles from that case. What Mr. Justice Aikenhead, brackets, now a very successful arbitrator, close brackets, said was that there was no need for every conceivable detail to be supplied just for the engineer or architect to assess the claim. And for my part, that is quite sensible and obviously right. However, what contractors need to know is that detail in submissions is your friend. A detailed submission is much more likely to be successful than a vague one. And that is just simply human nature. If you ask someone for a lot of money with not a lot of backup, then that is not a wise choice. However, if you've got more detail, more substantiation for your claim, then it is harder to reject. That is my view on the level of detail that needs to be provided with submissions for prolongation costs. I'm just going to end now with two short slides on proving a claim for prolongation costs, and this is something that Claire's going to build on in the next part of the talk anyway. 3 quick points and 1 overall point. The key when you are trying to prove a claim for prolongation costs is to prove the link between the costs incurred and the employer risk delay event. The first tip is beware of making a global claim. It is enormously tempting for contractors to do this. And if I were to give an example, it would go like this. Suppose the contractor budgets to spend £100 during a particular period of works, and they actually spend £130. And during the overspend, there was a period of employer delay. And so then they say, well, because there was a period of delay that was attributable to the employer, and I actually overspent, my prolongation costs is £30, which is the difference between what I budgeted and what I actually spent. Now that is an example of a low quality claim that I find is unlikely to be successful, because what's being proved there in a global claim is that there was an overspend. But what's not being proved is that the cause of the overspend is the employer risk delay event. It could have been, there could have been an overspend for all sorts of reasons, such as tender insufficiency, poor management of costs, changes in market prices, all sorts of reasons. Proving that there has been an overspend that simply coincides with an employer delay is not enough. Now, I should say that in Walter, Lilly and Mackey, Mr. Justice Aikenhead, as he then was, made it clear that there is no particular bar which blocks global claims from being made, but in my view and experience, and I'm sure Claire's too, making a global claim should be a last resort. What you need to try to do is prove your claim as best you are able by showing that there is an evidential link between the costs that have been incurred and the employer risk delay event. Second point is to make a distinction between time-related costs and task-related costs. Time-related costs are those costs that you incur simply because you are on site. So some types of management need to be on site from the beginning to the end of the job. You will need to incur premiums for insurance during that period. You'll need a site office, etc., etc. Task-related costs are those costs you need to incur simply to complete your scope of works. So for instance, piling equipment when you're doing the foundation works, a particular kind of crane to do a particular kind of work. The list goes on. Task-related costs generally aren't included in a prolongation cost claim because the contractor will need to incur its task-related costs just to complete the works. Now, if there has been a compensation event, to use the language of the NEC contracts, or some sort of employer risk event or a breach of contract, which means that the task-related costs get higher, that would more normally be a disruption, the subject of a disruption claim, which is outside the scope of this talk. We could talk for another hour about disruption, I'm sure. Now, third point, preliminary thickening. How these claims tend to work is that the contractor says, well, because of the weight of variations, I needed more design staff allocated to the job, or something like that. Now, preliminary thickening is one of those uncomfortable grey areas between disruption, variations, and prolongation costs. And really, we find that preliminary thickening could be put into any one of those three baskets of claims. In my view, the best way to claim preliminary thickening is to be clear and specific about why these costs have been incurred. Normally, there will be an event, a key event, that required the thickening to take place. So, for instance, if there have been a raft of design variations and as a result you need more staff, in my opinion, it is more sensible to claim the thickened preliminaries as part of a variations claim or series of variations claims, rather than lumping them all in with prolongation costs. And that's just because you're then being more specific. And the link between the employer risk event and the cost is clearer. Second point, don't double count them. If you're going to include this sort of human resource in a variations claim, be clear that you're not also including it as part of your prolongation costs. That's all from me. I'm now handing over to Claire, who's going to go through the standard forms.
Thank you very much, Sanjay. So just turning to the JCT quickly, that refers to prolongation costs as direct loss and expense. And just running through the provisions, just by way of a refresher quickly, the first point to note that people do often forget is that a relevant matter is required to claim your loss and expense. That is separate to a relevant event, and the two lists are not always the same. So you need to go to your contract and check, is it a relevant event? Is it a relevant matter? They're two separate things, step one. You then have an obligation to notify the employer, obviously, as soon as the likely effect is known. There is some debate as to whether that is a CP or not, and until that debate is positively resolved one way or the other, the best rule is to notify that as soon as you're aware of it or the effect of the relevant matter. get on with it, don't delay, as usual with CPs. Then you have obligations to provide information and to top up that information. If it is an ongoing event and you're going to have to top it up regularly, then it may be worth having engaging in a discussion proactively right at the beginning of the process when you first know this matter is happening to see what records an employer wants. You can have that discussion both ways, because ultimately at the end of the day, if this goes on for a while and you've put your records that the employer wants to them in the form they want, and it's going to be harder for them to challenge at the end, but equally the employer can be sure that they're getting what they need and that they can verify those costs. So that's something to think about. And in such form and manner as the employer may reasonably require. Again, it's the level of detail required. Engage in that discussion. Obviously, you can take it too far, but more detail is always going to be better for the claiming party as well as the person who's trying to verify that the claim is a genuine one and the quantum of that claim. And what is meant by direct loss and expense? In this case, it was defined as loss and expense which arises naturally and in the ordinary course of things. So that is effectively the first limb of the Hadley and Baxendale test, which is the standard causation test. This has to be actual loss or expenditure incurred as a direct result of that relevant matter. You need to prove causation. And formula are primarily for quantification rather than, well, they're not causation at all, proving causation, but we'll come back to the use of formula and how you might want to think about that or not later on. And then just confirming that interest and financing charges on direct loss and expense is recoverable, as confirmed in that particular case. So moving on to the NEC, which as we all know is a very different beast to the JCT. Compensation events, time and cost impacted. The impact of both is assessed together, not separately. You need to put in your claim for both at the same time, and there are time bars on notification. The whole process is about assessing your risk in advance, and it's meant to be based on a forecast. We'll come back to that in a minute. So you've got early warning notices, time bars to encourage early notification. But coming down to how it's meant to be valued, if it's being done correctly prospectively, the changes to the prices are assessed as the effect of the compensation to VON actual defined cost of the work already done, and then big dividing line, forecast defined cost of work not yet done, and the resulting fee. So in contrast to JCT, where you're not going to be forecasting things in reality, it's assessed on your actuals. NEC, if it's done properly, is meant to be on forecast costs. Park that there for now. In reality, CEs are often assessed retrospectively, especially if they're very high value and contentious, because people don't want to agree them, or they don't get round to agreeing them, or they're having arguments about proof and valuation throughout the project, and it ends up essentially being a final account dispute at the end of the day. So you need to keep your records to demonstrate your costs and to demonstrate that they have arisen as a result of that compensation event. Referring back to it being a forecast at the end of the day is unlikely, well, in our experience, very rarely ever succeeds if you don't have actual records and you're looking in retrospect. So this is the famous Northern Ireland Housing Executive case, which gets quoted in pretty much every NEC adjudication I seem to do. And I love this quote. It's, "Why should I shut my eyes and grope in the dark when the material is available to show what work they actually did and how much it cost them?" So again, it's just thinking about keeping your records. We all hope things are going to be agreed at the time, but in case they aren't, you need to be prepared. So defined costs in the NEC, just to flag, there are very strict rules under the NEC about how you value your costs, including prolongation costs, and they need to be followed. You've got the SSCC and the SCCC, and I've set out there which options they apply to. They set the rules for what is recoverable and the rates. And clause 52.1, the costs that aren't included in that defined cost are treated as included in the fee. First stop, what is in the fee, what is in defined cost. You need to establish that, because otherwise you could spend hours putting together an amazing claim on an element of your claim and find it's all in the fee, and that was a complete waste of time. And in terms of the other rules, the famous one that people always fall foul of is working areas. Have you defined your working areas properly? Is it clear what you mean? How do you prove someone was working in the working areas that day? And the classic one is, oh, we've got an amazing electronic signing-in system. It's brilliant. It's faultless. Brilliant. Was it working for the duration of the project? No. We shut it off for about 3 months during COVID because we couldn't do that. Excellent. Have you got signing records? Yes, somewhere. So you just need to think about how that works in practice. Get all your records together, because when you put that claim in, if you've got those records, tick, you know, brilliant. Other things to check for: bespoke amendments about job titles, how people described. Do the people you're claiming match those job titles? People can have amazing arguments on that. And if so, what rates apply? Think about these before you submit your claim and try and head them off. Again, equipment, plant, check what the rates, and check you can claim the costs. And then just moving on, record keeping, as I've said, you need to provide proof. With option C, for example, you have to keep huge numbers of records anyway, so, and including proof of payment, which is often one that takes hours to sort of prove at the end of the day. So just think about all these things and the fact that somebody might be inspecting them at the end of the job. So moving on, because I'm conscious of the time, to some specifics. First of all, on-site preliminaries and overheads, hoardings, fencing, site huts, cabins, those sorts of things. Again, follow the rules of the contract. The NEC approach is very different to that in the JCT. Shortcuts, they do occasionally work. If you've got a very good relationship and everybody knows it's a good claim, nobody gets the sense that anybody is taking the piss, and there's maybe an average rate for prelims in the tender, they think, people sort of think, well, do you know what, that's probably right. You can occasionally get people agreeing that. I've had that. That is not the correct legal approach. It is described as rough and ready in the case asking contracting. You are going to have to prove causation unless you can reach agreement. So just bear that in mind. Again, causation, you need to establish your actual costs. Question of fact, you need the records. Have payments been made? And think about mitigation. You need to show that you've done everything you could do to reduce those costs. Then in terms of when, what period are you claiming for? I think this is worth highlighting as well. The costs need to be for the period of delay you are claiming, not the overrun. And that's also in the SCL delay and disruption protocol. And if you think about it, that's logical. You've got a delay event, you have to prove cause and effect. The effect is going to be in the period of the cause or shortly afterwards. So that is something to think about that people often get wrong, and it makes a big difference to what records you need for which period. Plant and equipment, again, possible heads of claim that you might want to think about. Hiring charges if appropriate. Obviously, if you are hiring equipment and it's taking longer due to the delay event, then that should be a claim you can evidence. If you perhaps would be hiring the equipment elsewhere, you will need to show some sort of lost opportunity if you want to claim that sort of cost. Otherwise, think about depreciation, maintenance costs. They may be recoverable if it's going on for a much longer period. So turning to sort of off-site costs, loss of profits. So arising from a reduced turnover, and you can't tender for other work perhaps because you're so busy on this problem project that you just don't have the resource. You have to show that you could have used, you could have got more profitable work somewhere else basically, and you have to establish that on the balance of probabilities. So what sort of evidence is required for that? Well, the Water Lily case again is quite helpful on this. And I've just put a quote below. They've given evidence as to their historical tender success rate, and then sort of scheduled all the ones they've had to decline out in a witness statement in a lot of detail with the evidence attached. So if you're going to go for loss of profit on that sort of thing, that's the sort of thing you need to think about. And I should flag that we're going to talk about formulas for calculating that if you really need that later on. Claims for overheads. These are obviously incurred as part of a normal business. Your head office staff, lease payments, electricity, water, insurance, and those are distinguished from site overheads. And I should at this point say in the NEC you need to check what's in the fee, because a lot of these will probably fall in the fee. And the two types of claims, one is increased head office overheads because you've got to get extra staff in to deal with a problem project. You've got to prove that, obviously. So obviously if you have a letter to an employer saying we are going to have to recruit X number of people to deal with this, that would be handy. Otherwise you may struggle in retrospect without that sort of proof. Alternatively, lost contribution to head office overheads. We are not bringing in the income we expected because we're working so hard on this project, it's going on and on and on, but we're having to spend a lot of money on this anyway. You need to establish that they wouldn't have been incurred in any event, but otherwise it is a valid head of claim, and you'll see the standard chartered quote there. So formulas. Formulas can be used where necessary, and that is judge approved. You know, the use of a formula such as Emden or Hudson is a legitimate and indeed helpful way of ascertaining on the balance of probabilities what that return can be calculated to be. So a formula is not proof that you have suffered a loss. It is a calculation. It's assistance in quantifying the losses where you've already proved causation. Yeah. And I think that's pretty key. So the Alfred McAlpine case, again, a good quote on that topic there. And I'm not proposing to explain these formulas to you. That is firmly QS territory, but I thought I'd put there in case it's helpful. Key points to note is Hudson and Emden are profits and overheads. And I'm now going to realise that I'm going to say this wrong. The ELLIOTT formula is only overheads, and it's also an American formula that's typically used in America. So things to think about again for the Hudson formula, you have to establish that but for the delay, you would have recovered overheads and profits. You've got to have your tendering records available, as I've already said, to Lily. You've got to show there's no other possibility of recovering profits from other work, and that you suffered a reduction in turnover as a result of the delay. And it's not generally suitable where there's complex causes of delay. Interestingly, the SCL protocol does not support its use, which I'm sure would be quoted back to you if you did intend to use it. Instead, because it thinks there's an element of double counting in that formula, which is obviously a no-no, it prefers the Emden formula and the ELLIOTT formula. And I think I'm probably running out of time to go through the Norwest holes, but it gives some guidance on the sort of circumstances you could use the Emden formula or an Emden style formula to quantify your losses. And in relation to this ELLIOTT formula, it has historically been used more in the US rather than in sort of England, Australia, Hong Kong or Singapore. So query whether you really want to use it, but it is in the SCL protocol, so you do have some support there. So just rounding up at a breakneck speed, and I think we're on time. Always follow the rules of the contract. They are different, every contract. Causation must be established, and Sanjay has gone through in a great detail why costs and an extension of time, you know, different rules, and you might need to produce different types of evidence. You have to prove that loss you have suffered is a result of the delays caused by the employer, nothing else. And as ever in our talks, evidence is key for causation and quantum. You need contemporaneous records, even if it's an NEC and you're forecasting things. Shortcuts do normally backfire, although occasionally they succeed. And always approach formulas with caution. For the reasons that have been set out in the previous slides. And if you are going to use formulas, set out why and obey the rules for using them. Thank you very much.
Oh, well, thank you, Claire. Thank you, Sanjay. That was very, very, very detailed, very thorough, very informative. And I know that because of the number of questions and interests that your comments have generated. We've got time to take 2 or 3 of those questions. I've got a question about the Northern Ireland case, which I know that Claire talked about, but perhaps we can take advantage, I'm bearing in mind Sanjay's comments in relation to the but-for analysis and the fact he was prepared to express an opinion. Sanjay, do you consider that the Northern Irish approach is correct in relation to prolongation costs claims under the NEC form of contract?
It's a difficult question because we only have a Northern Irish case, and it is really the only British case on the assessment of compensation events under the NEC suite of contracts. So what that means is that it's the best we have for now. And I think that trying to persuade an adjudicator that they should close their eyes to a judgment of a High Court judge in Northern Ireland is not that appealing. And the other point, which I think is actually really important, is that I think it makes quite a lot of sense to say where there is a contractor and a project manager that disagree about what the effects of a particular compensation event is, and the time comes for them to adjudicate on it or go to court on it, that the adjudicator or the court might actually look at what happened. I mean, in most forms of dispute resolution, what we want is the evidence to play a role in the decision. And I don't think that necessarily the prospective ethos, if I could call it that, of the NEC suite of contracts necessarily precludes a court or an adjudicator from looking at the evidence of the actual effect of the compensation event, simply because there is meant to be a forward-looking set of agreements on site. If they can't reach that agreement, why not look at what actually happened? So that's my tuppence halfpenny.
Okay, Claire, is there anything you wanted to add?
I just say, in our experience, well, my experience in adjudications, adjudicators want to know that these costs were actually incurred and have evidence of that causation. I think people feel very uncomfortable with just relying on forecasts, especially if they're, you know, on the high side, without having, when they know that actually in 2 years, you know, that you've got the records. It's 2 years later, we've got the records, we know what actually happened, and there's, I think, a bit of unease to do anything else. But that's just a practical perspective rather than a legal one. And on the delay side, I know some experts I was speaking to recently said they do both, so they will do a prospective and a retrospective, and then, you know, hopefully they match up, but that's very rarely the case. But just so the adjudicator feels more at ease, or to avoid those sorts of arguments. That's not on cost, that's on delay, but it is something that's worth thinking about.
But I mean, I think that's absolutely right, and I don't think it's wrong for you to say that from the practical perspective, because when you're putting forward these claims in adjudication, you've got to think about the person you're putting them forward to, the adjudicator, and what makes them feel comfortable. Another question about someone who's been dealing with a prolongation construction case. I'm just asking, what's the criteria or test used to say reject due to insufficient explanation or evidence? Can you reject even if you believe a claim is justified? Sanjay?
Well, this sort of touches on one of the slides that I spoke to earlier, which is what Mr. Justice Aikenhead said in Water Lily, and specifically about the JCT form, but I think capable of wider application, which is that what the architect needs is what is reasonably necessary in order to assess the claim, and they can't insist upon every single sheet of paper that might be relevant in relation to the claim, and that actually feeds into the fact that often there is a time bar provision in the construction contract as to when this claim needs to be made, and so often, because of when the claim needs to be made, the contractor is not going to be able to provide absolutely every bit of backup that they could possibly have in relation to the prolongation cost claim, because often some of the costs won't have been incurred yet because, I mean, I've seen some amended FIDIC forms that require a contractor's claim to be made within 7 days of the circumstances giving rise to the delay. Well, 7 days after the start of the delay, you're probably going to know you're not necessarily going to know very much about how much cost you're going to incur. You probably aren't going to have incurred all the costs, etc., etc. So there's a trade-off between properly evidencing the claim and doing the best that you can within the time available. And I think that certainly the English law perspective, as I see it, is that parrying claims, the engineer parrying claims on the basis that there's insufficient evidence, is something that really should be reserved to when the contractor really hasn't done their best to evidence the claim. That's just my perspective.
Okay. Claire?
I think all I'd add is obviously whoever is assessing the claim has a duty to act impartially if they're an engineer or a CA, and they've got to remember that when they are assessing it. They've got to use their own knowledge. But also, if you just turn around and go, oh, not enough, I need X, Y, and Z, and completely dismiss it when you know ultimately it's a valid claim, the chances are it's going to carry on bubbling away. They're going to get their act together eventually. It may take years, but you know, it's adding to perhaps bad feeling on the project. It's going to get there eventually, probably, if you think it's a valid claim and that you're assessing it. So it's thinking about it in the round and maybe not just kicking it down the road, trying to engage to get the information and avoid ultimately a dispute that's going to cost everybody money.
Okay, thank you. I think we've got time just for one more question. I'm not sure where our questioner is from, but they've said that in the country of their residence, contractors are blacklisted if they fail to complete the task in time. Doesn't stop contractors coming around for bidding again. But how can contractors claim for excess costs incurred due to unreasonable prolongation? Claire?
Well, difficult balance, isn't it? If you know that you're due prolongation costs, certainly under English law, then you know you have a claim there. The question then becomes, how do you enforce that claim, and what are the consequences of that claim? If you have an arbitration provision and perhaps it's got a seat outside the jurisdiction that you're in, then you may be able to enforce that award. It then becomes a question of commercially, is the benefit of getting the prolongation cost back worth more to you than losing that work in the future? And that will depend on the values of both.
Okay. Yep, no, that makes sense. Sanjay, have you seen threats of blacklisting at all?
I have. I do quite a lot of work in the Middle East, and this is definitely something that one sees in that region. I think one of the things that I would note about the blacklisting and the threat of the blacklisting is that sometimes it can deter contractors from making perfectly good claims early in a because they don't want to run the risk of blacklisting early in the project. They want to preserve relationships, and it's only really when the relationships fall apart completely that the contractor starts making claims. I would say that this is really difficult. This issue is really difficult, and I think that from the earliest possible opportunity, a contractor needs to have a commercial strategy. If what you're trying to do is progress your claims through commercial negotiation primarily, so as to avoid the threat of blacklisting and things like that, just be aware that you might well be leaving an awful lot of money on the table through adopting that strategy. The second point is that if you are aggressive, be aware that you might be preparing the road for war, and commercial war, of course, and you need to get ready for that too. So just but flip-flopping between strategies, which is tempting, I've seen that go really wrong sometimes. because what ends up happening is that by the time you decided that you do want to progress these claims, you look backwards and look at all your notices and discover that you've put none of them in on time. So that's just a loose advice, which is frankly got almost nothing to do with the law, which is be sure to have a commercial strategy at the start and try as far as you can not to flip-flop.
Yeah, but that's good commercial advice. I think, Sanjay, that applies across the board, not just to prolongation costs or claims for potential prolongation costs. And with that, I think we are now out of time. So it just leaves me to thank both Sanjay and Claire for their presentations, for dealing with the questions so frankly and comprehensively. And thank you, our audience, for listening and participating with the questions. And hopefully you'll be able to join us with our next webinar in 2 weeks' time on Thursday, 25th November, when Catherine Butler and Olivia Liang will be talking about arbitration agreements. Something which in some respects seems such a small thing, but it's so important, because if you get it wrong, you lose your right to arbitrate. So hopefully you'll be able to join us then. But for now, thank you very much for joining us, and take care and goodbye.